Hello, and welcome to Doing Business As, the small business law podcast from Tracktown Law. My name is Jared Hight, and I'm the founder of Tracktown Law and your host for today's episode. At Tracktown Law, I help business owners across Oregon and Idaho build strong foundations, avoid common pitfalls, and protect what they're building without the fine print confusion. Whether you're starting your first LLC or managing a growing partnership, this podcast is here to give you the legal clarity to move forward. Today, we're talking about buy-sell agreements, and why, if you're in business with someone else, you should probably have one. Before we jump in, a quick reminder. I'm a licensed attorney in Oregon and Idaho, but this podcast doesn't create an attorney-client relationship, and nothing here should be considered legal advice for your specific situation. Let's start with the basic problem. Most partnerships start with optimism. You've got a great idea, a great partner, and maybe even some traction. Nobody wants to sit down and talk about divorce when the honeymoon phase is still going strong. But here's the truth. Your business will change. One of you might want out, one of you might pass away, one of you might get divorced, or move, or just burn out. And if you haven't planned for that, the fallout can be expensive and ugly. That's where a buy-sell agreement comes in. It's essentially a business prenup. It's a written agreement between business partners that says, here's what happens if one of us wants or needs to exit the business. Now, if you've already got a solid operating agreement, you may have buy-sell terms built into it, but many don't, especially the free templates. And even if they do, those provisions are often vague, incomplete, or mismatched to how the business actually works. So whether it's a standalone document or part of your core agreement, what matters is that your buy-sell terms are clear, enforceable, and tailored to the realities of your business. So let's talk about what a buy-sell agreement actually covers and why each piece matters. First, triggering events. These are the life events that kick the buy-sell agreement into gear. Common ones include a partner retiring, voluntarily withdrawing, dying, becoming disabled, getting divorced, or going bankrupt. In Oregon and Idaho, state law doesn't automatically give you clean solutions for any of these. If your agreement doesn't define what happens, you're either stuck in limbo or headed to court. Second is valuation. If someone's ownership interest is being bought out, how do you decide what it's worth? This is one of the biggest points of conflict in business exits. Should you use book value, fair market value, a multiple of revenue, an independent appraiser, set a formula now or agree to one later? A good buy-sell agreement answers these questions clearly, so no one is trying to retroactively argue the number when emotions are high. Third is payment terms. Even if you agree on a price, can the remaining partners afford to buy out the exiting one? Will it be a lump sum, installments, or a promissory note? Can the company use life insurance to fund the buyout? In many cases, having the right insurance in place can mean the difference between a smooth transition and a cash crunch that sinks the business. Let me walk you through a few examples from Oregon and Idaho businesses that didn't have buy-sell agreements or had the wrong kind. First, a 3-member design firm in Boise. One of the partners decides to leave after a few years to take a job offer. The firm is doing well, but they never signed a buy-sell agreement. The departing partner demands a third of the business's current valuation based on their current earnings and goodwill. The other 2 partners balk. There's no agreed formula, no funding mechanism, and no clear way to dissolve the dispute. Tension mounts, legal threats start flying, and within 6 months the firm dissolves, all because they didn't map out what exit would look like before it happened. Second, a husband and wife run cafe in Eugene. They brought on a longtime friend as a minority partner to expand into a second location. A few years later, the friend is diagnosed with a serious illness and needs to step back. They never created a buy-sell agreement, and the operating agreement is silent. The friend wants a buyout. The couple can't afford it, and there's no life insurance in place. The business can't survive with 3 owners and only 2 working. Eventually, the cafe is sold under pressure and nobody gets what they hoped for. Third, a 2-owner fitness studio in Bend. One owner goes through a divorce. In Oregon, if there's no agreement restricting transfers, a court could award the ownership interest or a share of its value to the ex-spouse, even if they have no involvement in the business. Without a buy-sell clause triggered by divorce, the remaining partner is suddenly dealing with a new co-owner they never agreed to. These aren't rare, they're normal, and they're avoidable. A good buy-sell agreement answers the questions no one wants to ask when things are going well. What happens if someone dies, gets divorced, wants out, wants to sell to a third party, gets fired, is incapacitated, moves across the country, gets sued, has to file for bankruptcy, and it doesn't just ask what happens, it provides a mechanism for how to handle it fairly. Let me add a quick word about funding. In most closely held businesses, buying out a departing partner requires more cash than the company has on hand. That's why many buy-sell agreements are paired with life or disability insurance policies. The company, or the partners, take out policies on each other, so if someone dies or becomes disabled, there's money available to buy out their interest without bankrupting the business. It's also common to use scheduled installment payments with a modest interest rate, allowing the business to spread the cost of a buyout over several years. That can be a win-win, giving the departing partner a steady payout and the business time to stabilize. I'll end with this. A buy-sell agreement is not about paranoia or pessimism. It's about respect. Respect for your business, respect for your partners, respect for the work you've all put in, and the reality is, the best time to create one is when everyone's still on good terms. Waiting until there's conflict, illness, or burnout is too late. If you've got a multi-member LLC or partnership and you don't have a buy-sell agreement, or if you're not sure what's in the one you downloaded from the internet, it's time for a review. You'll sleep better knowing you've taken care of the hard questions before they become urgent. If you want to go deeper on this topic, visit tracktownlaw.com for the companion blog post. It's got a written recap of everything we covered today, along with a few bonus insights for Oregon and Idaho business owners looking to future-proof their companies. In the next episode, we're talking about how to structure a multi-member LLC to avoid conflict from the start. It's a natural follow-up to this conversation and a must if you're forming a business with friends or family. Thanks for listening.